So here we are. So once again, my name is Teresa Kirk. I'm General Counsel for the West Virginia Ethics Commission. I appreciate you all joining us today. And we also, as part of the presentation, is, of course, the key person, and that is Terry Anderson, our Lobbyist Registrar. And I know that she's the person that you all normally interact with the most. So today we're going to cover several things about the Ethics Act and lobbying. Many of you have been registered as lobbyists for many years, and you know this, but hopefully it'll be a refresher or you'll learn something new. As a reminder, the Ethics Commission is governed by a board. Those board members are appointed by the governor. The commission consists of 9 members, and by code, they all have varied backgrounds. For example, the code requires that a member of the legislature be on the commission. There's another requirement that somebody who has experience in county government be on the commission. There are also some positions that I'll describe as at large. But one thing that the commissioners have in common as required by code is that they are not currently in public positions. So by serving on the commission and not being in other public positions, that allows them to use their experience, but at the same time not be holding another position which subjects them to the Ethics Act under that position. The day-to-day operations of the commission are overseen by staff. There are 6 of us. We are located here in Charleston, West Virginia on Brook Street. To those of you who are situated out of the state of West Virginia, that may not mean much to you, but generally we're not downtown, we're not at the Capitol, we're somewhere in between. On this slide, I put up for you the different areas that the Ethics Commission has jurisdiction over. Of course, you know that we have jurisdiction over the Ethics Act and lobbyists. That's why you're here today. The Open Meetings Act, and that may be valuable to attorneys or others who have to advise their clients on complying with that act. We do interpret that. We do not have authority to enforce that. Okay. All right. So back to about some of the areas of responsibility. One thing we're responsible for are the financial disclosure statements. Some of you all may file those if you sit on a state board. Other required filers are members of the legislature or certain candidates for office. The forms are due around February. And plus, in West Virginia, we have a filing period right now for candidates for some public office. Many of those candidates have to file them with the commission. Those are public documents. If anybody ever wants to see a copy, they can request one. And we also have copies on our website as well for certain public officials, such as members of the legislature. The commission also interprets and enforces the state administrative law judge code of conduct. That applies to individuals who preside as ALJs at the state level, so not at the local level. There's a county provision out there that we interpret. It relates to conflict of interest. County commissioners are one example of folks who are subject to that. And we issue school board advisory opinions. And what those are that school board members by law have to limit their outside political activities. For example, they can't hold another office. So for that reason, we were charged with the legislature with interpreting that. So, all right. So now we have my slide doesn't necessarily want to cooperate with moving, but here we go. I think we made it up to the next slide. Here I've given you examples of persons who are under our jurisdiction. They range. You can see I've got Marshall University there. Yes, the Ethics Act covers higher education officials and employees. There are many exceptions at the higher education level. We cover members of the legislature, boards of education, the other elected officials such as the Department of Agriculture and employees under those officials. A lot of times we'll get questions, and it may involve a person who's not subject to the Ethics Act. In the last couple years, a political party executive committee member asked whether they were subject to the act. The commission did the analysis and concluded, no, they are not. In a similar vein, oftentimes people who are on a nonprofit, even if it receives government funding, they may not be a public employee for purposes of the definition in the Act. On this slide, I've pointed out to you one of the what we believe to be the first advisory opinion issued by the Commission relating to lobbyists. That was issued in 1990. And here we had an association which was sponsoring a reception. And they essentially said, is it okay for us to have the reception? The response, of course, is yes. And they were seeking guidance on how to report the expenditures. I'm not going into what they advised because the law was a bit different back then. And what I mean by that is that when the Act was amended in 2005 for the lobbyist portion of the Act, the legislature added a provision which is known sometimes in lobbying circles as first dollar reporting. Before that time, the Act had this provision that if you spent just $5 on a public official, even if it was a series of expenditures, you did not have to report it. So, for example, if you bought them a beer or a Coke, then you didn't have to report that because it was under 5. Quite frankly, with inflation, most of those expenditures may be over 5. But nevertheless, in West Virginia, it is now first dollar reporting. So all your expenditures on public officials have to be captured on your report in some fashion. A reminder here about the gift rules in West Virginia. It is $25 per public official or employee per calendar year. For that $25 limit, I always like to think of tangible items. Let's say that you get somebody a clock for their desk or something similar. There are many exceptions to the $25 rule. I think the most known and used is the meals and beverages exception. So if you are purchasing meals and beverages and you are present, then it doesn't have to be $25 or less. So you can take them to a steakhouse. You do have to keep your receipts and report that on your report forms. The other exceptions are listed. For example, a ceremonial gift. I think of a plaque that has been engraved. You may have a situation where you invite a member of the legislature or another public official to a speaking engagement. The Act allows you to do that and to cover those expenses so long as they are reasonable. So if the engagement is for 1 hour to speak after lunch, you cannot put them up for 3 days. You cannot, while they're there, take them golfing. The other rules in the Act apply, but once again, you can cover the reasonable cost of their travel and lodging. Gifts that are purely private in nature, an exception there. And one of the most important takeaways is that the Ethics Commission gift guideline is available right on our website. So that can always be a reminder for you or for something you may want to distribute to your clients. I've shown here an example of what may be a purely private and personal gift. You've known somebody since childhood. You were in the Girl Scouts. Maybe you were in the 4-H club together, and you've continued to exchange gifts through the years. That would fall into that exception. Here we had a question arise just last year, in fact, where somebody, in lieu of giving a member of the legislature a gift, said, we would like to make a donation in their name. And they made this offer to several members of the legislature because they wanted to show their appreciation to them. And one said, yes, that would be nice. Could you please do that? So the lobbyist then said, well, how do I report that, or do I? And the commission issued this opinion and said, yes, you do report it. The $25 limit does not apply because that member of the legislature is not going to personally benefit. And you do nevertheless need to report that on your form. All right, let's say that you're at the state capitol and a senator comes up to you and offers you tickets to a football game, and the value is over $25. So this is the reverse. Normally we think of lobbyists giving gifts to a member of the House of Delegates or the Senate, not one of them coming up and offering to give you a gift. And the question is, may you accept that? Well, yes, under the Ethics Act, because they can give you as many gifts as they want, as long as it's not for some unlawful purpose. but there would be something to watch out for there. Let's say that there is a lobbyist who is also on city council and that senator lives in that same city. Well, then the lobbyist is also a public official and subject to the gift restrictions. So there could be a twist there. But in general, yes, senators or members of the legislature may give you gifts. Now, the converse of that is, may a lobbyist give a senator a gift over $25? So you go up to the senator and say, hey, I have W football tickets or Super Bowl tickets, and you can't give them to them. And most of us do not have Super Bowl tickets. But nevertheless, that gift is over $25 and may not be given to them. They can pay you the fair market value, which you would have to prove was the fair market value and what you paid for them. In 2021, we had a question from a police department, and what had happened there was a citizen came into the department, and they knew that she was coming, and she said, I want it as a show or of my appreciation and gratitude for all your hard work to give you this thank you card. In the thank you card were various gift cards to local restaurants. So the officers had not gone out and solicited these gifts. In fact, they are not allowed to solicit the gifts under the Ethics Act. The citizen did this on her own accord. And the chief of police, who is well aware of the Ethics Act and that there were gift restrictions, came to us to seek guidance on what to do with the gift of gift cards from the citizen. The Ethics Commission said there's several things you can do with them. First, you can distribute one valued at $25 to each officer, or they can keep one valued at that amount. Other ideas is that you may use them for a charitable purpose. But the main thing is that no, the officers in that situation could not keep a card valued at over $25 because that citizen did business within that community and was considered an interested party for purposes of the restrictions in the Ethics Act on gift giving. The act also contains voting restrictions. If any of you are public officials here in West Virginia, maybe you serve on a parks board, maybe you're a city council member, you're aware that if you have a financial interest in something, you may not vote on it. Normally that financial interest is going to be an ownership interest in a business that is going to be directly affected by a vote. It may be something affecting a immediate family member. If it's an employment situation, it may be a relative. In those situations, you would need to recuse yourself. For recusal to be proper, public officials at these levels have to disclose their interests and step outside of the room while the matter is being considered. But I want to turn to members of the legislature. Another rule applies. Many of you are aware that you watch the session. You know that each house or chamber has their own rules by which they are governed. And what the act says is that if a member of the legislature asks the presiding officer whether they should vote, then he or she is immune from Ethics Act prosecution for voting. So when they're on the floor, we've seen it many times where they stand up and they ask the presiding officer if they can vote, and the presiding officer will make that determination. Once they have done that, they are immune from prosecution under the Ethics Act for that vote cast. We're turning to private gain. This is a provision in the Ethics Act that we probably get the most questions about. The act does not expressly define what is private gain. It says that you may not, shall not use your office for your own private gain or the gain of another. The commission has a legislative rule fleshing that out some, but otherwise it's decided on a case-by-case basis. Normally it has to be tied to a financial gain, but not always. By way of example, in 2021, a college professor wanted to know whether he could invite a political candidate to his class to the exclusion of others to talk about his position in the race. The Ethics Commission ruled that no, that would be unlawfully favoring that candidate, and therefore that they could not have a policy whereby you would invite one candidate to the exclusion of others to speak to a classroom. There's exceptions. Somebody may be a candidate, but they may be there to talk about things from a historical perspective. I've got a picture of Abraham Lincoln up. Maybe they're there because they're an expert on Lincoln. So there could be exceptions there. As far as other limitations on public officials or things that they're allowed to do, yes, they can politically endorse candidates. We see that often. A member of the legislature will endorse a presidential candidate or a local candidate. In 2012, a sheriff asked if they could use their title to endorse their chief deputy. The commission ruled that they could. A different angle in 2019, a law enforcement officer asked, well, I'm running for office. I'm currently a police officer. May I wear my uniform in my campaign advertisements? And the commission ruled that the officer could not. Essentially, it was found that the uniform and the insignia belonged to the public agency and the government agency, and that would be use of office to use that uniform while they were a current officer in campaign material. Under the Ethics Act in general, it does not prohibit public employees from running for office. They always have to check their own rules with their HR department, or there's other laws out there, such as the Hatch Act, which limits the political activities of certain people who are in positions funded with federal funds, or they may hold a position in the federal government. Under the Ethics Act, though, in general, so long as you do not use your government time or resources in furtherance of your campaign or your outside political office, then it is permissible. Under the private gain provision, the rule of law is that public officials cannot use their public job title or their likeness for a commercial endorsement. In 2005, there was a higher ranking public official who wanted to appear in a television ad for a car business. And it was not his. He had been requested to do that based upon his position. And the commission ruled that would be an unlawful endorsement. Conversely, in 2015, a member of the legislature said, well, I have private business interests. How does that apply there? And the commission said, it doesn't restrict you in your private capacity from going forth with your private business endeavors and doing what you've always done or may elect to do, and that would be appear in a television commercial. You just cannot appear in that commercial and use your title. By example, if you're an attorney, you can't say, we don't get paid until you get paid. I'm a state senator. Use the law offices of Jones and Jones. You need to keep your public title out of the business advertisement. It can be listed in your biographical material. The Ethics Act contains restrictions on nepotism. I've listed on the screen who are considered relatives for purposes of the nepotism restrictions in the Act. The general rule of law is that you may not be involved in hiring a relative or taking action which affects their employment. The Act also restricts public officials and employees from having an interest in public contracts over which they have control. So by way of example, if you're on city council, then city council cannot hire your construction company to clean up debris after a flood. There are exceptions. There's a 1,000 threshold that you may fall within. Exceptions for part-time appointed board members. They can't use their office to unlawfully influence the award of a contract to them, but they can contract with state agencies if they're part-time appointed board members. Members of the legislature may contract with government agencies as well, because that is in the Act. And as a member of the legislature, they don't exercise direct control over awarding agency contracts. Here, I note on the slide for you that even if a contract is permissible, that public servants still must remove themselves from the process, and they cannot receive special treatment. Recently, we just last ethics commission meeting, a state board member had asked whether they may award a contract to another state board member, and that other board had a relationship with the state agency. And the commission said that it was permissible. Here, that other state agency had exercised no control over this contract. The person who was going to be awarded the contract had had no involvement, and the commission said that was fine. I want to talk briefly about restrictions under the Ethics Act on seeking employment. Now, right in the act, it states that full-time public employees may not seek employment with or buy, sell, or lease property to or from any person who, and there's 3 categories listed there. One would be matters in which they or their subordinate took regulatory action on within the past 12 months. Another category is if they currently have a matter before your agency, or if it's a vendor over which they exercise control. If you are an employee of the Division of Highways, this could come into play if you're an engineer and currently you have oversight of another engineering firm that has a contract with the Division of Highways. In that case, you cannot seek employment with that engineering firm unless you take steps to comply with the Ethics Act. And I'm going to talk about those here in a minute. It may come into play for you all as lobbyists if you want to interview a full-time legislative attorney and the session is going on, or maybe the session is concluded. But in that instance, I would encourage the attorney to contact us for advice, or you may contact us as well. These restrictions on employment would not apply to employees whose duties are ministerial in nature. Back in 1991, there was an employee at the legislature and their duties were ministerial. They might have, I forget their specific job duties, but that employee said, I would like to work for a lobbying association or business for a short time to help them with their annual conference. And because their duties were such that they could not affect the interest of that lobbyist or their clients, the commission said that for purposes of applying the Ethics Act, that lobbying association could hire that legislative employee. All right, I told you I was going to talk about how somebody can seek employment and comply with the act. They can do that by getting an employment exemption. This is different than revolving door. This is not an exemption that says the commission hereby finds that you are not subject to the post-employment restrictions in the Ethics Act. For example, some people have to wait 1 year before registering as a lobbyist. What an employment exemption is a mechanism to seek employment while you're still employed by a state agency. We'll go back to that example of the engineer who works for the Division of Highways. If they want to speak with that engineering firm about the potential for employment, what they need to do is get an employment exemption from the commission. The way they do that is they direct a written request to the executive director, who's authorized by the rule and the law to issue a temporary exemption. Once they are granted that exemption, they give it to their boss. If they're going to interview or discuss employment with that engineering firm, then they would have to be removed from matters affecting that firm, which is a vendor of the agency. The exemptions are considered by the Ethics Commission at their regular meetings, or they're ratified at that time. They are granted upon a showing that the public employee would be adversely affected if they first had to resign or quit their current employment before engaging in employment discussions. So that's the threshold for proving the need for an exemption, and they are normally granted on that basis. The question here is, may a lobbyist serve on a state board? So let's say you get a call from the governor's office and they're requesting that you serve as a board member. And the answer is that you may, but you may not participate in any decision which affects directly your financial interests as a lobbyist. So if a question ever comes up about that, or you're asked to serve on a board, you are welcome to call us if you want to discuss with us whether there's any potential for conflict. Another question that I've gotten in the past is, well, what if I have 2 clients and they take different positions on pending legislation? For those of you who have been in that situation, I'm sure that is difficult, stressful, and not fun, particularly when it's in the middle of the session. But that is a conflict of interest question normally for you to resolve. It's not one resolved by the Ethics Act. There is a provision in the act that says you may not introduce legislation for the purpose of having being paid to defeat it. but rarely will that arise, and it's unlawful. I do caution that if you're an attorney, you may want to call the state bar to determine what your duties are under the rules of professional conduct. Here we had the question back in 2011 if it violated the Ethics Act for a public agency to hire a lobbyist. The commission said that there's no provision in the Ethics Act that controls that question. It's a public policy question. I do have an alert here. The legislature has put in the code that Chapter 30 boards may not hire lobbyists. For those of you who are out of state, you may not be familiar with the term Chapter 30, but those are generally our regulatory boards in West Virginia. So the boards that regulate the practice of medicine, nursing, barbers, and cosmetology. Here we had a state board member, and they asked whether they may be employed by a professional association whose members are regulated by the state board on which this board member served. And the commission said that they may do that. For state boards, oftentimes the requirement in the code is that a person with experience in the field or currently in that industry be on the board. For that reason, there's exceptions in the act. And once again, normally the act will not bar service on that board. We discussed financial disclosure statements earlier. If you're a required filer, normally you will get a notice of that at the time of your appointment. Or if you're a candidate, when you go to submit your filing, there'll be notice in there that you are a required filer. The Ethics Commission is charged with enforcing the Ethics Act. I've outlined the complaint process for you. There's a 5-year statute of limitation. There's more information about the complaint process on our website, and there's a procedural rule on complaints as well. I give you that information because it's part of the act. But for those of you who are attorneys out there, you may be requested to represent somebody in a proceeding. And those are some of the areas where you would look to find information about the act. I've also listed here on this slide the sanctions under the act. If you ever have any questions, we want you to feel free to call. You're welcome to email as well. It's whatever is easiest for you. You may also request a formal advisory opinion. When you call, we may know the answer. There may already be an advisory opinion on point, or maybe the language in the act is clear. But if we do not know the answer, we may request that you seek a formal advisory opinion, or you may just decide to do so. You don't need our permission to request a formal advisory opinion. They are considered by the commission at their monthly meetings. The names of the requesters are not put on the agenda. You also are welcome to call in and listen to the commission meetings. On the agendas, we have the call-in numbers. So at this point, I'm going to go ahead and turn it over to Terry, who's going to talk more about the nuts and bolts of lobbying.
Okay, first I wanted to unmute myself. Okay. Am I sharing, Teresa?
Looks like you're sharing. If you want to click a slide to see if it'll move, you're welcome to do that.
Oh, yes.
It did.
Yes. Yay, we're good now. Okay, good morning, everyone. This is the lobbying part, and it's just mostly the administrative part of lobbying. And lobbying is any communication with a government officer or employee for the passage, defeat, approval, or veto of legislation, or the adoption or rejection of any rule, regulation, legislative rule, standard, rate, fee, or other agency action. And a lobbyist is compensated to lobby or spends over $150 on public officials. Okay, every lobbyist must register before they begin lobbying activities. And to do that, we have forms on our website. The fee is $100 for registration. and $100 for every employer you represent. Now, we're unlike most states in that we don't require the employers to register. You must complete lobbyist training within 90 days of registration. The registrations are 2-year cycles, and they begin on odd number years. And it's very weird how the term ends. The term ends on the Monday before the second Wednesday in January, which for most years, except for leap years, that would be the Monday before the legislative session starts. You may add employers or terminate employers at any time during the registration period. And we do not give ID badges anymore. We have electronic PDF files, so you can just keep them on your phone. And here's what a registration statement looks like. Hopefully down the road, we will have online registration, but we don't have the capacity for that yet. They are always on our website under the Lobbyist tab. And here is an example of the employer representation authorization paperwork. There are registration exemptions, and you do not need to register as a lobbyist if you only attend receptions or dinners, or you appear and testify before public sessions of legislative committees. If you're a nonprofit and you work at the legislature less than 20 days per session, news and media employees, government officials and employees, and persons rendering professional services or advice to clients regarding prospective legislation or experts. And the revolving door, which Teresa touched on in her presentation, and these are who must wait 1 year before registering as a lobbyist, and they are members of the legislature, Board of Public Works, Supreme Court of Appeals, the will and pleasure professional employees under the direct supervision of a member of the legislature, and the will and pleasure professional employees under direct supervision of the Board of Public Work member who regularly, personally, and substantially participate in a decision-making or advisory capacity, executive branch secretaries, and state department and agency heads. Now, grassroots lobbying, and we don't have very many grassroots lobbying campaigns right now, but this is lobbying directed to the public and not to a legislator, and it's to call the public to action, like call your senator and tell them to vote no. That would be a grassroots lobbying. Now, not everyone needs to register. It's just anyone who spends more than $200 in 1 month or $500 in 3 months. There is no registration fee for grassroots lobbying, and the reporting requirements and dates are the same as lobbyist dates. Okay, now we're going to get into activity reporting, and that deadline for the last reporting cycle of 2021 is due January the 18th. So they are required 3 times a year. The late reporting fine is $10 per business day, and it does not exceed $250. And failure to file or pay fines can result in suspension. And the suspensions are notified to the legislative clerk and the media, and it's also put up on our webpage. And what are you supposed to report? Any expenditures made by you or your employer on a public official, their immediate families, to further your lobbying activities, including meals and beverages, lodging, advertising, and travel. And this is different ways to report. On a Schedule A, that's where you would report a gift. Of course, it's $25 or less. And if you give a reception to one of the chambers of the legislature or one of the standing committees or a joint committee, you can put these on the Schedule B report. And on this report, you do not have to list everyone who attended. You just have to have a number, because what you're going to do is figure out the cost per guest and then multiply that by how many legislators and legislative employees attended. Now, on campaign contributions, this gets, this is the one thing I have the most questions on. And that is, you only need report campaign contributions that you personally make or your spouse or a dependent make from a joint checking account to an individual who currently holds office. You do not have to report contributions to a PAC or contributions that your employer makes, only the ones that you personally make. And we just need the total of the campaign contribution and not to whom you contributed. Now, just remember that you must file a lobbyist activity report 3 times a year, even if you had no expenditures or you did not lobby. And these expenditures must be listed and attributed to employer if you have more than one. And you may amend your report at any time after the original submission with no penalty. You do not have to report your compensation, your personal travel or living expenses, or your office expenses. And here is an example of the lobbyist activity report form. And you might not see this again. I'm happy to announce that next week, I'm going to start testing our new online expenditure reporting application. So once I've finished testing it, which should take a couple of weeks, I will start giving training on the online system, and you all won't have to worry about paperwork anymore. What I requested to be built, and the State Office of Technology is building this for us. They've done a really good job. I'm so excited to share it with you, and I think you'll be happy with it too. Here is the example of the Schedule A. This is where you would report if you took out 1 or 2 senators or 1 or 2 delegates, but not a whole group. This is where you would detail the expenditure on that person. 1A is gifts, and you can do that as a group if you gave every senator a flag for their desk. You could lump that in a 1A. And the participation in the panel or speaking engagement is reported on 2. And then 3 under this schedule is the subject of your lobbying. And here's Schedule B. This is the group entertainment and shared expenses. And the difference between the two is the Schedule B is for specific groups. And they're listed here under number 4, which is the legislature, either chamber of the legislature, a standing or select committee, or a joint committee of both houses. You don't have to list names. You just have to have the number of participants. We've already talked about the campaign contributions. Just remember, these are only contributions that you or a spouse or a dependent give through a joint checking account. And we don't need to know who you contributed to, just the total amount. There is a place on the paperwork for that. And what we're doing here right now is training. You're required one training every 2 years, so you will not need to train again until after January the 9th, 2023. We do provide virtual training or person-to-person training when we're not in a pandemic twice a year in January and October. Other providers may seek certification from the Ethics Commission to provide training. So if you know of someone who just really wants to do this, they would have to go through us to get the training approved. And of course, we do have the online video if you choose to train with the video. And there, of course, you all know there are some restrictions in lobbying. You cannot engage in any lobbying activity before you register. You cannot lie to any public official or employee about any facts pertaining to a matter which is the subject of your lobbying. And do not participate in any decision as a member of a state or county governmental body if you may receive direct personal financial benefit from your participation. Do not cause or influence the introduction of any legislation for the purpose thereafter being employed to secure its defeat. I believe Teresa touched on that one. Do not exercise undue influence, extortion, unlawful retaliation upon any government officer or employee by reason of the government officer or employee's position with respect to or his or her vote upon any matters which is the subject of your lobbying activity. And do not exercise undue influence upon any legislator or other privately employed government officer or employee through communication with the person's employer. Any registered lobbyist who willfully and knowingly makes a false statement, conceals a material fact, or otherwise commits a fraud in the application, statement, or report is guilty of a misdemeanor, and upon conviction shall be fined up to $1,000 or sentenced to 1 year in jail. A person who is subject to lobbyist registration and reporting requirements but fails or refuses to register or fulfill reporting requirements may be the subject of an ethics complaint and face the same penalties as public officials. A person required to register as a lobbyist has certain obligations, which, if violated, could result in the termination of his or her registration and or lobbying privileges and possibly the subject the lobbyist's employer, if the employer has knowledge of the violation, and to other civil liabilities as prescribed by law. And there are things to remember. If you are terminating, we do have a termination notice, and you must use that to let me know that you are terminating. And that termination notice does have a section for your last expense reporting on it. Now, if you do not terminate, then the next time you're required to report and I don't receive anything, then, after the specified number of days, your lobbying privileges would be terminated and suspended. And if you wanted to re-register again, you would have to turn in the reports that you did not file and pay the fine. And the one reason we ask you to keep your receipts for 2 years is because every year we have a compliance audit, and 20 lobbyists are drawn by a CPA at random. And what the CPA will do is review your expense reports and make sure that you have the proper documentation. And this does include campaign contributions. So if you do make a campaign contribution, make sure you keep your bank statement or a canceled check, because the CPA will want to see that. Another thing to remember is lobbyist records are public records. So please be sure when you fill out your registration papers that the main number you put on there is the one that you want public, because it will be public. There is a space on the paperwork for a secondary number. So just remember that your address and the main primary phone number on your registration are public. And please notify the commission when your contact information changes. Here's an example of the termination notice. If you'll, for example, number 4, that's your expenditures. And so that would be your last expenditure report. Now you can use this form to either terminate a specific employer or specific employers, or to completely terminate your registration. Those boxes are at the top. Just be careful for which one you check. And that is the end of my part of the presentation.